People, it is a depth HNIC battle rap and investing, man. Shout out to everybody in the chat. Shout out to all the righteous heterosexuals. Without us, there would be no them. Shout out to all the Christians, the Hebrew Israelites, even the Muslims. All right, man, check it out. So y'all remember the paperwork that we read from August, the court appeals hearing. My bad, I have a sore throat, man. Pause if anything. Pause if anything, if necessary. But I got a sore throat. Not feeling that great. But if y'all remember the paperwork from August that we read, that was pretty much Chris's lawyers trying to argue like these motions to suppress the GPS data. They were trying to file motions to throw away counts 4, 5, and 6 because of a bunch of things. We all remember when we broke down that paperwork. Remember they had Chris's truck. It was impounded for like 2 years. The lawyer said, "Oh well, we wanted to go test the truck 2 years later, but you know somebody smashed the window or some stupid shit like that, right?" But they didn't. They said, "No, fuck you, nigga. No, that shit don't matter." But the motion they did allow was the motion to suppress the cell phone GPS data, right? So this was the appeals, the hearing that we pretty much read the transcripts for. It's actually crazy. Like it's crazier watching it than actually reading the paperwork. So I'm gonna play this for you guys because this is actually the hearing. They actually have this. I'm very surprised. So let's just get right into it, man. I'm still got a little 45 minutes left at work, so I'm gonna holler at y'all in a bit. I'll probably come in here and there if necessary. All right, but salute to everybody, man. Shout out to y'all. Appreciate it.
Good morning, Your Honors. May it please the court, opposing counsel. My name is Tom Williams. I'm an assistant district attorney at Stone Mountain Judicial Circuit, and I'm here today because the trial court got it wrong when it granted a motion to suppress physical evidence obtained from the appellee's home pursuant to a search warrant. And the court got it wrong for one simple, plain fact. What the lead detective, Katrina Evans, testified to at that hearing, what she told T-Mobile at on the exigency request, does not matter. Rather, under the Fourth Amendment, we look to an objective standard of review. When we look at this case, the exigencies of this situation made it compelling to conduct a warrantless search that was in fact objectively reasonable. The court got it wrong by using the wrong analysis when it conducted its hearing, and it got it wrong by applying the Franks v. Delaware standard or test in considering a motion to suppress outside the context of a warrant application. Before we can discuss how the law applies, we must first understand, how the case came about. Detective Evans happened to be working the weekend shift in DeKalb County when she responded to a rape call at the DeKalb County Medical Center. Ms. Simeon indicated that she had contacted a male through a phone number to arrange a ride for hire or a cash taxi. When she got into that vehicle, she was sexually assaulted. In this case, she alleged that she was vaginally penetrated in the front seat of the vehicle.
Chris, I thought they were no longer pursuing your case. I thought you said that they were no longer pursuing your case. You no longer had any court dates, and you weren't going to trial. Right. As you see my guy right here, Thomas Williams, a.k.a. the Big Speaker. The Big Speaker. If y'all remember when we read the paperwork. He's telling the appeals committee, you got it wrong. This man is a monster. We should be suppressing no evidence that puts him at the place and times of these crimes. This man is a monster and he will rape again.
The only thing that the officer was able to obtain was a general description of the assailant and a phone number listed there on the record as 404-940-9442. Detective Evans was beginning her investigation of that particular allegation and to conduct that when the following day, early morning hours of the 18th, another victim came forward, Karen Hill. Karen Hill told detectives and officers that she'd been at a nearby bar, that she needed a ride home, and found a person offering her a ride, then also sexually assaulted her. In this case, that person attempted to force her to provide oral sodomy. In each case, both Simeon and Hill were able to give general description of the assailant, able to give a general description of the vehicle associated with this, and they each suffered similar injuries. In each case, the vehicle was moving when they escaped it. In each case, they suffered road rash injuries. In each case, they're able to identify generally the vehicle as a black SUV. Ms. Simeon, because the facts turned out that she'd seen the vehicle on the way to the hospital, was able to give a slightly better description of a black Ford Expedition with a partial tag. Now, as I say, the lead detective happened to be the same person in each case. She personally interviewed Ms. Simeon and Ms. Hill. She came to the reasonable conclusion that these two cases were connected. They were connected very close in time, within 24 hours thereabouts. They were connected by nature of the alleged assailant being between 5'10" and 6 feet, being stocky built or sort of heavier weight, being between 30 and 35. And she was also to recognize that there was an element of escalating violence. While Ms. Simeon had gave no statement regarding a weapon, Ms. Hill told officers that she saw a gun. And she, in fact, suffered a cut to her wrist that she could not explain, but the call went out as a person stabbed call. In light of this ongoing and chaotic situation where there's back-to-back rapes within 24 hours that are closely connected, Detective Evans then sought more information about that target phone number and sent a exigent circumstances request pursuant to federal law to identify the subscriber and the location for that phone over the last 48 hours. The next day, and we can see here, that was sent on the 18th. In other words, within 24 hours of her identifying that phone number and within hours of her understanding that these two cases are connected. That request is sent to T-Mobile and responded back on the 19th. In light of that information, Detective Evans did not simply go to the location. She did not simply seek a warrant. Rather, law enforcement officers conducted public surveillance of the location. That location happened to be in Rockdale County and was the Appalese residence. They were watching the home because we have an ongoing emergency. The police are worried about the potential for a third rape, a potential for a third sexual assault. So they're watching the suspect, but are not acting on that observation. As they're watching the house, law enforcement observes two important things. One, there's a black Ford Expedition in the driveway. Two, a male comes out of that house and observed by law enforcement officers, matching the description that Miss Simeon and Miss Hill gave to law enforcement. It is on that information that Detective Evans then goes to the Rockdale County Magistrate Court and gets a warrant based on that to search the home. And it's important to understand because the litigation at the trial court level was about that exigent request, but because of the court's ruling, the court also suppressed a number of items of physical evidence to include the fact that Miss Simeon's phone was located in the Appalese attic, that she left that phone in the.
So you heard him just say, just like we've been telling you in the paperwork for the last few years, y'all keep saying we're lying, we're making this up. The cell phone was found in his attic. Why would the cell phone be in his attic if she left it in his vehicle and he had no knowledge that he had her phone? He hid it in the attic.
The subject vehicle in the Appalese attic, that she left that phone in the vehicle, the subject vehicle, when she escaped that rape. And they found that target phone in a bedroom closet. The touchstone of the Fourth Amendment, in any case.
Mind you, they just said that the phone he was using to post the ads on Craigslist for the cash taxi, that was found in his bedroom closet, hidden in a shoe. And remember, it was set to vibrate. All right, he was hiding it from his wife.
There's always reasonableness. The court, however, the trial court, however, conducted what I would call it the Franks v. Delaware test in this case, and looked at the writing given to T-Mobile and examined that under the Franks v. Delaware test, that famous test where law enforcement officers in an affidavit, an application for a search warrant, cannot lie or act in reckless disregard for the truth in their application for a search warrant. And that's the wrong test to use. The fact is that Franks v. Delaware is a warrant application case, and that a warrant application.
So you're saying that it's okay for an officer, I'm not going to say she did this, but to make up a bunch of stuff in an exigent circumstances request that they're going to send to one of our cellular providers. They can make up a bunch of stuff, and that's okay?
Well, no, Judge, that the remedy there is a private cause of action. If she misled T-Mobile into doing some action, then she would have a private cause of action. The question before this court.
Who is she?
I'm sorry, she used the wrong pronoun. The appellee may have a cause of action because of that. The question for the court is, was the request objectively reasonable without regard to the nature of the request or the words written in that request? Was there an exigent?
Now, mind you, for people that we watched this, we read the paperwork. He's referring to the document that the detective used in order to get T-Mobile to send that data. She stated that there's a potential serial rapist on the loose. Okay? Now, Chris's lawyers trying to find loopholes and everything. They said, well, technically, Karen Hill wasn't raped. She was just forced to put a dick in her mouth. So technically, that's not rape. So when you wrote that the man's a serial rapist, that's not true because he only raped one girl, and then the other girl he didn't even get to fuck. This is Chris's lawyer's defense, by the way.
Agency that justified objectively the search. And when we look at that comparison chart and we look at the record, which is available to your honors, and you owe no deference to the trial court's findings because these are uncontroverted facts, you'll see that these assaults were closely associated both in time and the nature and the generally matching description of the assailant and vehicle. So the search, without regard to whatever she told T-Mobile, whatever Detective Evans told T-Mobile, was objectively reasonable and therefore authorized.
So it doesn't matter what she says in the request.
Under the Fourth Amendment analysis, we go past what she said and look at the facts known to the officer. Would those facts lead a reasonable officer to draw the same conclusion? Was her actions objectively reasonable under the Fourth Amendment?
So her kind of exaggerating things, which is basically what it looks like she did, is, just sort of make it seem a little bit worse than maybe it was. Even if the actual circumstances are okay, that doesn't matter. I know it doesn't matter from T-Mobile's perspective. They're just reading they don't need to go underlying it and do investigations. If they get a request that seems on its face to be exigent, they can turn over the records. That's no big deal. But I don't know how that necessarily equates to the police getting to just get away with making up or exaggerating or making things up in order to get information that then leads them to things when they could have just gone a warrant probably to begin with.
That's so pathetic. That's so pathetic that a woman could say that. So are we really gonna act like forcing a dick in a woman's mouth is not in the same realm as rape? If you ask me, I say it's rape. I say that's rape. But listen, this is pathetic. It's absolutely pathetic how the judicial system works. We already broke this down when we read the paperwork. So,
well, it's interesting you mentioned that, Judge, because we have to recognize that this search was done, or this request was done in 2017, pre-Carpenter, and so the appellee had no expectation of privacy in non-content phone records at the time. And the courts have consistently held in this state that actions happened before Carpenter do not implicate the Fourth Amendment. And to answer your sort of concern about exaggeration, I would point your honor to Franks v. Delaware again. Negligence or exaggeration is not the same thing as dishonesty. And so even under the Franks v. Delaware analysis, which really does not apply in a non-warrant context, as far as I can tell, her exaggeration, as you say, or sort of, I'm going to say inartful statement, is not lying, and she didn't mislead anyone But that still doesn't matter because she was facing an emergency that required immediate action that was compelling in her capacity to protect the public.
Well, you know, the trial court like specifically discredits the officer's testimony. You're saying we don't have to, we can just ignore that as well?
Well, I think you owe the court a great deference as to findings of fact, unless there's ways to review the record for uncontroverted evidence, such as, and this was admitted into evidence at the hearing, Ms. Hill's recorded statement to the detective, Ms. Hill's report to the officer, Ms. Simeon's recorded statement to the detective, all that's available. So you'll know exactly what Detective Evans knew when she decided that this was an ongoing emergency that required an exigent request. And so while Detective Evans was an uncommonly bad witness, in fact, when you view the record, you'll see that she was under bond for a material witness warrant where she refused to come to court on a without subpoena. One's not surprised that her testimony was discredited by the trial court, but it doesn't change the underlying fact. The objective analysis comes to the conclusion that the exigent request was authorized because there's an ongoing chaotic situation that reasonably led an officer to conclude there was a public emergency requiring action over and above the warrant requirement. Moreover, the warrant requirement would not apply.
And more directly, you focus on that public emergency. And I think you've defined it for the court, but if you'd redefine it for me again, since this is an exigent circumstance request, so what is the exigency? What is the immediate ongoing, I think you said ongoing emergency?
Yes, Judge. Typically you see exigent circumstances as hot pursuit. That's sort of the traditional law enforcement concept. But there's also a public safety exigency. A common sort of law school understanding of that would be a crying baby behind a door that would require entering a residence without a warrant in order to prevent imminent harm to a person's property or the public. Here we have sexual assaults within close in time, the potential for escalating violence, and the potential for a third victim. And I would cite, Your Honor, to Swinson v. State, a very similar case where there were two murders and a potential for a third that led GBI to get an exigent request, very similar to the case here, with an inartful application. But the Supreme Court looked at the totality of the evidence and found that GBI's request was objectively reasonable in light of the facts known to that GBI agent.
And the exigency was alleviated, would you agree, from the fact that you had the suspect under surveillance at a certain time prior to getting the search warrant? Is that correct?
Well, the surveillance is exactly because of the exigency. They didn't know if they had the right person, but they had to be watching for fear that there would be that third rape the following day. And with that,
thus really this court needs to focus on the exigent circumstance request, because without it, does your search warrant collapse also?
The court found that sort of the fruit of the poisonous tree doctrine would apply here. I would urge the court not to focus on the request so much as was there an exigency that supported that request, as opposed to the document itself, because that's not the question. It's not her subjective intent that matters, but rather the objective evidence that would support that. And with that, I'm going to reserve my last minute unless there's any further questions from the court. Thank you.
Thank you, Your Honors, and may it please the court. My name is Kyle Winchester, and I, along with Jason McClendon, we have the privilege.
I told y'all he has these Kazars as his lawyers, these dudes who spent their entire careers specializing in helping rapists get off based off of loopholes and technicalities. And he looks just like I thought he would look.
Of representing Christopher Bernard Gunsby, appellee in 1444 and cross appellant in 1445. I'd like to start this argument where Judge Fuller left off, which is, does the search warrant collapse if the exigent request is bad? The answer to that is yes. Everything hinges on the real-time data that was procured from T-Mobile as a result of this exigent circumstances request.
Do you agree with the prosecution, though, that now we can ignore the writing itself as long as there were objective facts that would have supported it had this officer written it appropriately?
No, Your Honor. Then the two reasons why. The first reason is that Franks has been extended outside of the context of a search warrant affidavit. While there is no Georgia precedent expressly extending it to an exigent circumstance request, courts have extended it to other statutory circumstances like a wiretap application. And so the point of Franks is to give the defendant the opportunity to challenge the credibility of statements that were proffered to a recipient that he at the time could not cross-examine or develop further. And that's exactly what we're doing here. Secondly, even if we were to go past the language of the exigent circumstances request, the state's position still fails because factually, the facts known to Detective Evans gave her significant reasons to doubt that these two allegations were related. And on page 16 of our responsive brief in 1444, we lay out a litany. I think it's 10 or 12 objective circumstances of which she was aware prior to her submission of the ECR that showed compellingly that she had reasons to doubt these allegations. And I think that's the key.
Maybe there were differences in the circumstances, but they were kind of close in time, and you've got a similar vehicle and seemingly a similar individual being described as committing either an attempted rape or a rape and some type of a sexual assault, even if the conduct wasn't exactly the same. So even if there were distinctions as to Craigslist or how they found, the one that was met at the bar, you still have somebody potentially committing two crimes within the same person committing it within a short period of time is one way to look at it.
Close in time, yes. Same vehicle, no. A very key important part of this is the interview of Michael Rucker, who was the third-party independent witness who observed Karen Hill, victim number 2, exit the vehicle as it was stopped outside his home. The interview of Michael Rucker shows that Detective Evans specifically asked Mr. Rucker, did this vehicle have distinctive rims? She's asking that question because in the interview with Simeon, alleged victim 1, that was one of the key identifying facts, was the car had distinctive rims. The car had distinctive rims. Detective Evans asked that question because she was predisposed to look for that fact from Simeon. Mr. Rucker's response, the sober witness in this situation, is no, it did not have distinctive rims. So this is.
How do you know if Michael Rucker even knows about vehicles like that? If he's even a car guy, if he would even notice the rims, if he would even notice that they're distinctive in the first place? This is such a reach. It's the biggest reach that they're doing in terms of trying to defend this dude, Chris. Well, the girl said that the rims were distinctive, and Michael Rucker said that, well, the rims were not that distinctive. Like, bruh, what distinctive? What do you even mean by that? What do you even mean by that? Because what could be distinctive to one person is not distinctive to the other. And mind you, Michael Rucker just saw the vehicle spinning off while Karen Hill was getting out of the vehicle and she was running down the street. What are you even talking about? It's such a reach. It's such a reach. But I have faith that this is not going to work out. Also, this appeals court, this is about the GPS data, which is in regards to Kiara's case. This has nothing to do with Shannon, by the way. This has absolutely nothing to do with Shannon.
Is a fact that does not corroborate her suspicion that these two acts are related. And then there's
but you're still talking about, people's recollections of things. We talk about witnesses all the time. Somebody might see somebody and think it's brown hair. The other one said, no, it's red.
Right. Talk your shit. Talk heavy. Exactly. It's such a reach.
But it turns out it's the same person. Their perceptions of things are different. So whether someone thinks rims, if you're talking about a big black SUV, you can nitpick all those things, but isn't there sort of generally the idea that within a short period of time in a location where two women get, accosted sexually in ways that might be enough?
Not standing alone, because you have to believe that she believes that these two allegations are linked. If she has reasons to doubt that they are linked, then there's no exigency. And so that's the key with this, is that
the officer herself has to have no doubt.
No,
how is that ever to never have any doubt?
Talk your shit. Here we go. I was getting mad at this lady, but she's talking her shit now. What the fuck are you even talking about, dog?
agency. And so that's the key with this, is that
That the officer herself has to have no doubt. I mean,
not,
how is that ever to never have any doubt I mean, when you're doing your job in this circumstance?
not that she has to have no doubt, but if the objective circumstances available to the officer at the time that she submits this request support substantial reasons for her to doubt her own statements that she's submitting to the provider, then objectively an exigent circumstance does not exist. And there was plenty of that. She stated that she had identified Ms. Simeon on a known pandering website prior to submitting this request. She had taken Ms. Simeon in a vehicle back to the crime scene where this had happened. Ms. Simeon, in her interview, told the detective that this act occurred in the middle of the street. They go back to the abandoned house and they find her sandal 100 yards up in this driveway. The detective is asking her, how did this happen? How can you explain your sandal got here? She has no answer.
Do you not so we go back to the paperwork, because we're going to give more context, because we've been following this case for years. If you go back to the paperwork, there's another witness that actually helped Kiara at that time. There was a neighbor when she jumped out of the vehicle when Chris was speeding off. She went to the neighbor next door. Her and the neighbor went back outside and found Chris at the same place where the rape occurred. You don't know what he did. You don't know what could have happened. Maybe the shoe fell off in the truck, and then he threw the truck out the window. He threw the shit as far. There's so many things that could have happened there. This dude is reaching. He is reaching every step of the way. There's so many things that could have happened in between that time. And also, if you go to where the rape occurred with Kiara, it was in pitch blackness. It was in pitch blackness in the driveway of an abandoned house. So it's like this dude is reaching, dog, and it's sick and it's pathetic, man.
There was a litany of reasons. I mean, it's laid out more specifically in the brief, but there were a lot of reasons for the detective to doubt. From the first moment that she interviewed Simeon could not describe where she got the number. She couldn't state who she got it from. She couldn't identify where she was going. She didn't have money to pay for a cash taxi. You think someone needs cash to pay for a cash taxi? Didn't have that. It's just and that's the reason that she is investigating.
What's funny is they're trying to use the word cash taxi like it's literally like, no, you can have a cash taxi and still get paid in Cash App or Zelle or PayPal or maybe Venmo. Okay? There's many things that could be in regards to that. And also, you're lying. She said that where she got the number from. She got the number from her cousin. She got the number from her cousin who got it from Craigslist. So again, what are you talking about? And also, there would be records of Chris picking her up from the hospital. Again, we know the whole story about how the cousin first got Chris's number. And then she recommended the number to her cousin, which was Kiara Simeon. Come on, dog. These dudes are sad, man.
Further, right? That's the reason that she's asking Michael Rucker for an interview. That's the reason that she waited 2 days to execute the search warrant. The statement in the ECR is, the analysis predicts he's going to rape again tonight. She proffered that to the provider and then got the search warrant, but didn't do anything with it for 2 days. That undermines the entire premise of her proffered exigency, is her failure to execute the search warrant. So there's a lot of objective circumstances in this case that showed that Detective Evans was not confident in her representation to the provider that these two allegations were linked. And the reasons were there were dubious inconsistencies associated with both. I heard...
And exactly, remind me of what was obtained by law enforcement from the exigent circumstances request.
I hope you mentioned the butt plugs, nigga. Shout out to Kelly for the Cash App. She said for obtaining this video. All that love goes to sales, man. State sales. That brother has been working hard behind the scenes to get a lot of this paperwork, a lot of these videos, the transcripts, all of that. Shout out to state sales for real. But appreciate you. Thank you.
What was actually obtained?
48 hours of real-time GPS location data associated with Mr. Gunsby's cell phone.
Which resulted in law enforcement being able to do what?
Identify Mr. Gunsby's cell phone inside the address at 3875 Partridge Place in Rockdale County.
That resulted in the surveillance that counsel mentioned to us a moment ago.
Correct. And the attempt to then go to the Rockdale County magistrate judge. And this is where we drew the analogy to the Kylo case from the Supreme Court, where the Supreme Court condemns the practice of using high temperature sensing data to reveal intimate details from within the home. They say that's a search. In that case, it was flying a drone over a house to sense how much electricity is being used to find out that there's a marijuana operation inside the home. But this is the same thing here.
And then the ultimate search warrant resulted in the seizure of the cell phone of the alleged victim?
Yes, Your Honor.
And so then your argument to this court is based on what the public might refer to as a technicality.
Yo, I know this nigga didn't just say it. I know this nigga didn't just call him out for trying to just run off of loopholes and technicalities. Shout out to this brother. Shout out to this Edomite brother. Because Esau was still our brother at the end of the day. This man just told him, you coming into my house and you're trying to run off of technicalities? They found the victim's cell phone hidden in the attic. Yo. Shout out to this nigga. Facts. What the fuck are we even? They found the cell phone in the attic. So what Chris's lawyers are doing with this, like, that's why I've been telling you, his entire defense is not that Chris didn't rape these women. It's just based off of technicalities and loopholes. That's it. Because you would think the GPS data would actually help him, right? If you're an innocent man and you didn't commit these rapes, you would think the GPS data would help him. Wow.
In the seizure of the cell phone of the alleged victim?
Yes, Your Honor.
And so then your argument to this court is based on what the public might refer to as a technicality, if you will. But if this court agrees with the trial court, then the cell phone that was obtained through the search warrant will be suppressed and not used as evidence, correct?
It's correct.
Which then I think results in your position that you want the court to consider reversing the trial court on the counts that would be, under your argument, dismissed against the defendant, correct?
Look, people, he's scrambling and scraping. He choking, just like RBE's lawyers and Norm's lawyers. Look at him. Look at him. He's stuttering, people.
The defendant, correct?
By the way, the counts that they're talking about being dismissed would be 4, 5, and 6, which would be Kiara. Okay, which they denied his motion to dismiss counts 4, 5, and 6, but they did allow the suppression of the GPS data. Okay, that's funny as hell. This nigga is scrambling and scraping.
The defendant, correct?
Yes, the counts that we've challenged in the motion to dismiss are the counts that relate to the same victim whose phone was found within the house. That's true.
Yo, you see how sick? You hear how sick he sounds? Nigga, you sound fucking sick. What the fuck is wrong with you? Yeah. I mean, yeah, I guess with this technicality, yeah, we're trying to just throw away the counts that have to do with the victim, you know, where the victim whose cell phone was found in the nigga's crib, hidden in the attic. The fuck are we talking about here, dog? This is a joke. This is a joke. Tell this man to get the fuck out.
Yes, the counts that we've challenged in the motion to dismiss are the counts that relate to the same victim whose phone was found within the house. That's true. So there's separate arguments to reach the same goal. But But I would not submit that this is a technicality. I would submit that this is an outright Fourth Amendment violation. I mean, in United States versus Leon, the Supreme Court created good faith exceptions, but it noted that.
Nigga, it's a technicality. It's 100% a technicality. You're saying, okay, you found the bloody knife and the used condom, and the knife has the victim's blood on it, but you wouldn't have found it if you didn't do that, though. So technically, yeah, get the fuck out of here. Like nigga, this is literally a blatant technicality that you're trying to go for here, which is an admission of your client's guilt, honestly, in my opinion.
Where that does not apply is where law enforcement engages in misconduct, reckless disregard for the truth, and that is precisely what the trial court found. The trial court took a very big step here to reject wholeheartedly the credibility of this detective, and that factual finding, that credibility determination.
Mind ya, in terms of credibility, quote unquote, they're talking about Detective Katrina Evans writing on the exigency report that 2 women were raped. Well, technically, Chris only got to rape one of the women. The other woman, he just forced his dick in her mouth. So technically, technically, that same type of voice. Hold up.